Thank you, Mr. Assistant President. Good lawmaking requires the courage to make necessary changes, but also the wisdom to listen to the views of stakeholders so that the changes made work well and work for the benefit of the whole community. Getting the settings right first is always better practice than tinkering for years to amend overreach. The bill before us aims to address the use of good character in sentencing. It builds on the exception, part of the law for almost 20 years, that the good character of an offender is not to be taken into account as a mitigating factor if the court is satisfied that this factor was of assistance to the offender in the commission of the offence. It addresses recommendations from the Sentencing Council and seeks to remove from courts the ability to use considerations of character in the sentencing process. But it would be superficial lawmaking to simply look at the headline recommendations and not look also at the submissions made to the Sentencing Council and the informed views of stakeholders, which raised important issues not reflected in the majority recommendations. These issues were amplified by the inquiry held by PC5 into the use of good character in sentencing. It is because of these issues, from stakeholders across the spectrum, that we will be seeking to amend this bill, so we can get this reform right the first time and not cause unintended harm to those before the courts. Those opposed to the blanket removal of all consideration of good character proposed by this bill include the Law Society of New South Wales, the Bar Association and the Aboriginal Legal Service. The Law Society in their submission recognised the trauma and distress that the criminal justice system, including sentencing, can cause to victim survivors and supports trauma-informed approaches. They pointed to the need for more holistic reform rather than what they labelled as piecemeal legislative reform. To properly address the trauma of victims in the legal process, they called for action to address the current lengthy delays in proceedings. I note in this regard that according to Boxar, the median time to finalise trials in the District Court has risen from 783 days in the financial year ending June 2023 to a drawn-out 826 days in the financial year ending June 2024. This is well over 2 years from the date of arrest, an extremely long time for a victim to wait for final disposition. The Law Society also calls for action to address underfunding of legal assistance and victim support services, including the New South Wales Victim Services, and notes the need to address the involvement in sexual violence matters of personnel who have not undertaken trauma-informed training. Sadly, none of these matters are addressed by this legislation or appear to be the subject of work by the current Attorney-General. This is a missed opportunity to really address the causes of trauma for victim survivors. The Law Society recognised the impact on victim survivors of a judicial officer acknowledging an offender's good character in sentencing and support the reduction of this harm insofar as possible. They acknowledge the difficulties of the terminology of good character, but go on to note, quote, that the substantive material that is currently termed good character evidence can be an important factor in sentencing and should not be barred from consideration for categories of cases or all cases more broadly. They submit that, quote, such material can assist judicial officers to deliver individualised justice by meaningfully assessing other factors relevant to sentence, such as the offender's prospects of rehabilitation and likelihood of reoffending. This in turn can work to keep the broader community safe and appropriately tailor the deployment of Corrective Services New South Wales resources. Helpfully, their submission points to other issues for victim survivors which need to be addressed to prevent their re-traumatisation. A number of court precincts, particularly in regional areas, are unable to accommodate requests from victim survivors to deliver a victim impact statement and observe sentence proceedings remotely. Moreover, there is no legislative entitlement for a victim survivor to attend sentencing proceedings via audio-visual link. The legislature has recognised that complainants in sexual assault matters should be permitted to give evidence remotely, and has provided the victim survivor may read their victim impact statement remotely in those proceedings. But attendance at the sentencing proceedings is not covered. Again, if this legislation was really directed at addressing the re-traumatisation of victims in the criminal justice system, these are small matters, these are simple matters, but these are important matters that could have been covered in this legislation, which could form part of the current work project of the Attorney-General. But they appear not to be under consideration at all. Drawing on the experience of practitioners, the Law Society observes that it is unsurprising that, quote, victim survivors who wish to attend the sentencing proceedings may balk at the prospect of being in the courtroom with the perpetrator. This is due to the strong emotional reaction provoked by the close presence of the perpetrator and their corresponding desire to avoid having their reactions and appearance witnessed by that person. Court precincts should therefore be better equipped to ensure that victim survivors are able to participate in sentence proceedings in a manner that minimises the risk of re-traumatisation, and the legislation should enshrine the right of victim survivors wishing to observe the sentencing proceedings to do so remotely. It is disappointing that these practical measures for the benefit of victim survivors have not been addressed by this legislation. It's as if one item has been cherry-picked and only that item addressed, and it certainly makes me wonder how much real work has been done by this Attorney-General to address the range of issues which are encountered every day by those in the criminal justice system. These measures suggested by the Law Society of New South Wales are simple and helpful measures to avoid re-traumatisation. Social media campaigns perform a valuable role in highlighting issues which need change. But we shouldn't only be legislating in response to these campaigns and avoiding other insights, especially when they are being expressed on behalf of the traumatised and the vulnerable, who may not be in a position to identify systemic problems or advocate for them to be addressed. Both in the Sentencing Council review and in the PC5 inquiry, important voices were raised on behalf of women. The Feminist Legal Clinic, for example, pointed to the complexity in a number of domestic and family violence matters and submitted that domestic violence matters should not necessarily be subject to the proposed new rule. They pointed to situations where the predominant victim of violence is convicted, with the consequence that the predominant aggressor will be afforded more power and more control due to the barriers that that criminal record may create. This is a result that no one in this place wants. And the law currently has a mechanism to deal with this, a Section 10 dismissal. But what is the really important evidence to support a Section 10 dismissal? Evidence that can be tendered by the defendant or their legal representation as to good character and good character references. These should not be done away with in the context of Section 10 dismissals. The Feminist Legal Clinic recognised that every case is different, but submitted that there are some circumstances in which good character references are appropriate, especially in domestic and family violence matters. This law provides for a blanket abolition. That will have unjust consequences. It will be unjust for a number of women. It will be unjust for a number of predominant domestic violence victims. It is a blanket approach when a more nuanced approach is required. We want this law to improve the situation for victim survivors, not make the position of some, especially where they are the predominant victims of domestic or family violence, worse. and that is exactly why we will be moving amendments to this legislation. We're all in furious agreement across this chamber, I am sure, that we wish to the extent possible to prevent victims of crime from being re-traumatised by the legal process. We recognise that this happens and that this is a perverse outcome. But we also recognise that the best path to achieving this community good is a more nuanced and more complex approach than simply removing any access to good character in sentencing. We support the intent of this bill, but recognise that it needs to be amended to be able to properly achieve its stated aims. There have been arguments that retaining any ability to reference good character in sentencing benefits the privileged and the wealthy. But the evidence of practitioners, the submissions from people with actual experience of the criminal justice system tell a different story. I think the words of the Aboriginal Legal Service provide the best example of why this bill, with good intention, needs to be amended to achieve its aim. As the Aboriginal Legal Service observed in their submission, we recognise that in some cases, good character as a mitigating factor has operated to the benefit of individuals with privileged backgrounds. However, as we have seen through our practice experience across New South Wales, good character is not synonymous with social privilege. For our clients, good character as a mitigating factor can enable a court to take into account a client's contribution to their community, even where they do not hold privileged social status, such as providing social and community support to others, including elders and young people. It would be a perverse outcome indeed if we actually harmed the most vulnerable in a misguided attempt to stop those with privilege exercising that privilege. And it is because we are listening to the voices of those without social position and those without privilege that we are seeking to amend this bill, conscious that we either amend it now or in a couple of years from now, after well-intended but under-considered amendments have done real harm.
Honourable Robert Borsak.